Legally Speaking with me, Tarun Nangia. Today we embark and we are continuing our series on organized attack on judges in the social media. In the past few weeks, we have seen that uh, unsubstantiated comments are being made on judges without evidence. Judges can't respond, as we all know, on the allegations made, and of course they have a duty to perform. Politicians, if you criticize them, take a press conference and respond. Judges are unable to do that, and anonymous accounts numbering in thousands, when they attack judges, looks like a paid for organized attack. It doesn't look like some normal human being identifying himself and venting his anger or criticizing. It looks like a planned activity, and that is what makes it dangerous. Today we're going to delve into this issue, and I have with me a panel of specialists who are at the Supreme Court almost every day, day in and day out, also at various high courts, and they are seized of the matter. I want to welcome Justice Rishikesh Roy. As you all know, sir has served as the member of the Collegium at the Supreme Court until recently. So he's seized of how many issues are dealt with in the Collegium, having been a part of it. You see him frequently on Legally Speaking. Good to see you, sir. Thank you for your time and looking forward to your insights. We have with us Mohit Saraf, managing partner of law firm Saraf and Partners. It's a full service law firm. One thing about Mohit, I must tell you that he speaks his mind. Many times, people may like it or not, but he will call a spade a spade. I think that is what his USP is. Good to see you, Mohit, and look forward to be your usual self today on the show. Uh, I have with me a new entrant on the show, somebody who has a large law firm based out of the city of Mumbai. Amit Nayak is managing partner at Nayak and Nayak. He joins us from the city of Mumbai. Thank you, Amit, for joining in. Thank you for your time. Uh, Amit is somebody who has a wide experience to litigation in various and diverse sectors. That said, his law firm is also a full service. Good to see you, Amit, and look forward to some interesting insights.
Thank you for
At
having
the,
me.
Thank you. At the outset, let me request Justice Rishikesh Roy to make the opening comment on this issue. Over to you, sir.
Uh, Tarun, thank you for having me over for this program. Now, this is an increasingly visible phenomena of people being targeted across social media. And when the target, target can be anybody, it can be a politician, it can be a bureaucrat, it can be a socially active person, and also judges and lawyers as well. Now, the problem when we attack a judge, the problem is not just individual to the judge, but is also to the institution that the judge belongs to. The judiciary and the judicial institutions and judges function on a foundation of credibility. When social attacks are engineered, and here I'm deliberately using the word engineered because very often trolling happens in an organized fashion, not individual persons, but similar kind of comments are being made by a large group or somebody sitting somewhere, organizing a large group of people, and the judges are being targeted. In a situation like this, when people's attention span is nowadays increasingly seen to be at a very decreasing trend. I mean, you have a 20-second clip, and whatever opinion the viewer forms on the basis of that 20-second clip, there's no foundation laid for the allegation made. There is no analysis for why a certain comment is being made. And very often, the impression that is gathered by somebody watching or viewing these images or social media or reels, as they say, is left wondering why these kind of false allegations are being made. Now, we have now truth, falsity, and social media truth within court. What is there in social media, nobody is able to ascertain whether it is based on any truthful foundation or allegation, and the net result of such allegation is that we are made vulnerable, the credibility of the institution is affected. And I may just share my little experience in the bench, particularly when I was the Chief Justice of Kerala and when I was a member of the Collegium. Very often, when you are considering a lawyer from the bar for elevation to the bench, now it gets known, it gets circulated. Immediately, particularly in the office of the Chief Justice of the concerned High Court, or nowadays it will appear in social media, anonymous complaints are addressed. Now, these anonymous complaints, we all know, those who have been part of the institution, that so and so is being considered for judgeship. He should not be considered for judgeship. And they will make all sorts of wild and reckless allegations. If somebody similarly is being considered for Chief Justice of the High Court, he is also or she is also targeted nowadays by social media, and earlier anonymous letters, etc. It was not an uncommon thing to see. So it is nowadays, it is a manifestation in the social media. But the problem nowadays is that the complaints and the trolling, it has become multifold. It can be in thousands and lakhs. And even though you will expect a judge to be stoical about it, it is very difficult to actually imagine the kind of trauma that a judge would have when he's subjected to such trolling. And then also kindly think, I would request the viewers to think how he will be discharging his judicial responsibilities when he has to discharge in a calm, with a calm mind, without being disturbed by any external factors, and concentrating only on the facts which he is dealing or she is dealing at the particular moment. So these are some of the initial comments that I feel needs to be made, and perhaps a mechanism is imperative, which will deal with similar such situations, because a judge is actually left helpless. He can't be actually speaking in defense. Traditionally, we have always believed that the judges are supposed to speak only through their judgments, and more or less the judges follow that dictum.
Thank
Right.
you. Thank you for that opening comment. I'll go to Mohit Saraf, Managing Partner, Saraf and Partners, for his opening comment on this issue.
I think Justice Roy has actually covered a large part of it. I think what we all need to think about is we need to understand that there are conflicting interests. One is independence of judiciary and respect for judiciary. That needs to be maintained. On the other hand, transparency, we need to bring models of transparency and accountability. So, therefore, digital comments should not be curtailed. There are two conflicting interests. I think the more important part is that there needs to be a restraint on communication. And as I think it is an open secret that a judgment can be criticized on merit, and that is not a contempt. It and everybody has a right to agree, disagree, but you do not have a right to defame a judge or to by or in other way to bring down the institution of judiciary. I think if even in the Prashant Bhushan case in Supreme Court held that even truth is not good enough a defense, because even if it's truthful, but still if it brings down dignity, if it is not in the bona fide interest, if it is not in the public interest, then this is defamatory and it brings down the integrity. I think clearly what you just mentioned, that hundreds and thousands of people attacking sitting High Court and Supreme Court just as Justice Roy said, that before any of their elevation is possible or things like that, there is a concerted attempt to defame such individual. These things are very strict. This bring down not only the individual but the entire institution. And I clearly believe that in light of what Prashant Bhushan case the ratio was, we should think about how to build mechanism, even if it is whether it's a Twitter or whatever it is, how to bring a mechanism that wherever these accounts are being, or whether such comments are being posted, how to bring it down. And I think, Justice Roy, you should think about is there some way where the judiciary or Supreme Court actually through an official statement can, because really if you do not say it's wrong something, then this continues as a gossip. So is there a way where officially Supreme Court or High Court or some court can officially say that they have checked the fact and this is incorrect? If say something like that can be done, because we all need to understand that whether it's politicians, as you said, they can do a press conference or they can reply on Twitter or others can do that. Judges can only reply through judgment. And a lot of issues about personal life and things like that, they cannot reply. And therefore, this continues as a gossip. And as what Justice Roy said, the last person will only believe what he's heard, and he believes that that's truth. So there should be a way to make sure that people understand that it is incorrect. Somebody has validated it, somebody has looked at it. I don't know how feasible it is, but some of these things can go a long way to help the process.
Thank you, Mr. Saraf, for your opening comment. Now we'll go to Amit Nayak, managing partner of law firm Nayak and Nayak. Amit, you many people here may not know you come from a judicial family. Your father served this country as a judge, so you understand what is the kind of restrictions also that come into play when you are even a family of a judge, and from that generation, because you yourself are in a sense of a certain age, so you've seen judiciary through the ages. uh, Given all of that in mind, and what is your opening comment on this sensitive issue?
So first of all, Tarun, thank you very much for having me on the show. I must say that I can't match the eloquence of my fellow panelists, but let me make an attempt. Let me start by saying this. I singularly call this, and I see this on a daily basis. And as a civil lawyer in court, I deal with this quite regularly. I call it the menace of social media. Point number one. Point number two, I'm very clear, and I concur with what Justice Roy said and what my colleague Mohit said as well. Ultimately, it's the institution that is defamed. And look, this is a concerted attempt, and most relevant is the timing of this. That's the third point. It's really the timing that these miscreants choose to damn the institution. And I think that is very key. What I personally believe, and I say this with a sense of responsibility, that ultimately the law, and Mohit put it more eloquently than I could ever, Prashant Bhushan judgment is jurisprudence prior to, the law on defamation was that the only defense of defamation is the truth. The question really is that today, how do you defend this? I personally believe that in the technology age that we are today, social media is here to stay. I also believe that there are three things that singularly I would recommend. One is, like we've done in many cases, where we've done it for celebrities, where we've done it for protecting people. Ultimately, the intermediaries are responsible for passing on this message, and the intermediate guidelines under the Information Technology Act need to be more stringent. Penal consequences need to be there. And I think we need guidelines and frameworks on contempts of courts, because ultimately these are all sitting judges and it's the institution that you're attacking. But more importantly, I liked what Mohit said. I think a time has come that, like you have the wings, the three army chiefs speaking and a spokesman, I think a time has come for every high court to have an official spokesperson. I think that time is now. You can't say, because today when there is live streaming, Tarun, going on, and every citizen, please understand, unlike 10 years ago, the judiciary is in the open. A common man, a judge, this who is approachable, judge who's not a, it's this is how clients walk into our offices, and that's the opinion they form. And that's the, and I Mohit will bear me out on this, that's what we have to deal with on a daily basis. It's the challenge that we as attorneys, solicitors, and counsels need to dispel on a daily basis. The only way that can happen is by having an official spokesman for the institution, including the Supreme Court or the judges. This is where I would make my opening remarks and say that this is the time, and this is the time is not better than this. That's all.
Thank you for that opening comment, Mr. Nayak. I'll go to Justice Rishikesh Roy. One thing that I want to ask is that if an identified person makes a certain criticism, where you go to his account, social media, you can see his name, so you know who the person is. But when we see accounts who we don't know who they are, maybe they are anonymous accounts, or maybe the owners live abroad. Uh, do you think there is a remedy to such criticism? Because in case a person is not identified and he's making wild allegations, can the registry do something in this case? Maybe approach the social media platform and say that anonymous people making comments need to be sort of, in a sense, that needs to be taken off. Uh, because there is no clarity on this, could you share what could be the solution? What are the possible, or do you need a law? What is it that is required?
Well, Tarun, I think a couple of very valid points have been made by Mohit and Amit in their opening remarks. Now, Amit had used the word menace, social media menace. Now, all of us, we have grown up with a comic character, Dennis the Menace. Now we are having the social media the menace. So, how do we deal with a situation like this? We are seeing increasingly an orchestrated phenomena. It is suggested that we should have a mechanism within the High Court or even the Supreme Court to firstly, there has to be possibly a defense mechanism when we talk about protecting the institution, and maybe an offense mechanism to bring to book the people who are orchestrating this campaign. Now, defense mechanism is where suppose untruths are being bandied about. The people who are viewing this, they have no way of determining or verifying that these are correct allegations or entirely false narratives. In that case, if we have a mechanism, as is being suggested by Mohit, if we have a mechanism in place, either in the Supreme Court, an identified person who will be responsible for verifying, because very often you see at a given moment, at a particular time, when something is big is to happen, these are orchestrated, that somebody will verify and then say that there is no truth to all this campaign that is going on in the social media. This is one. So once this particular statement comes from the designated authority in a given court, at least those who have the responsible, who would like to be responsible in their perception, will know that although such things are being said, but let us hear what the authority will say. And then if they juxtapose what the authority clarifies as false narrative, then they will understand that there is no truth to what is being said. So that is one can talk about as a defense mechanism for protection of the institution and the judges. But then, so far as the offense mechanism is concerned, there one would have the difficulty, and there the intermediaries, the platforms through which this campaign is being registered or launched, they must be made accountable. That look, such kind of false narrative is happening, and hundreds and thousands of posts are being are seen and being bandied about. So are you not having little bit of responsibility, if you know that these are false narratives, to stop it, to prevent it? Will you wait only for a court order? There could be an ombudsman kind of a mechanism. There could be a self declared mechanism. But something must be done, because otherwise, by the time some corrective measures are taken, damage, a very huge amount of damage may happen. Somebody who is, say, destined to be elevated from the bar, because of the campaign that is being made, he might miss the bus. And when you miss the bus at a given point of time, even if you are elevated, say 2 years later, you become junior to those contemporaries who are being considered together with you. That is so far as elevation at the judge level is concerned. Then suppose you are being considered for elevation as Chief Justice to a High Court, and such campaign is registered, you lose your seniority, and very often, because of the age of retirement, you might lose the opportunity to go to the higher position. So these are consequences which cannot be, reversed. So therefore, something needs to be done, is what I feel. What is possible? Of course, this debate is not adequate to give an answer.
Thank you for making those observations. I'll go to Mohit Saraf, managing partner, Saraf and Partners. Mohit, one thing that I would want to know: a judge's job involves keeping his mental equilibrium intact. I know you wouldn't want to go and argue a matter or your firm when judge is disturbed. And imagine with these kind of allegations, how even judges are human beings. How are they supposed to keep their mind at a certain equilibrium and then judge and decide when they can't respond? Somebody who is abusing them day in and day out and they can't respond, and then they are hearing the most important matters. Given this as a fact, do you think a law or the registry can do something? Some ecosystem, some system, some law, something needs to be evolved. So, anonymous abuses should come to either a short, or there should be some remedy. It can't be a free for all. Because if it's a businessman, he'll go to court, get an injunction. Anybody else also, if he speaks against a lawyer also, he will bear consequences immediately. But we are seeing people are speaking against the judiciary and just getting away with it. Your How do you put sense to this issue?
I tell you one thing: anonymous viewpoint is something which is a right. Lot of people want to express. Even in law firms, people give suggestions in suggestion boxes which are anonymous. So I think we have to respect that people will comment, and sometimes they do not have an ability to put their name, and therefore that entire social media platform and the laws should allow anonymous view to be expressed. I think that one part we should not take away, because that's going to be a bad way. I think the question here is, we have to understand whether it's a managing partner of a law firm, whether it's a lawyer, whether it's a political activist, whether it's a doctor, everybody is affected equally when there is a campaign against him. And therefore, we have to understand that this is a problem which will continue. I think the question is not that we should start looking at these issues. I think if there is a campaign against me in my firm or in social media, I will be affected. And we have to probably understand that this is a cost we have to pay. And sometimes people will go and express themselves, sometimes people will not express. But I think the question here, what we have to think about is basically the Prashant Bhushan case, that if there is a malified campaign which brings down the dignity of the court, of the judge, it's a personal campaign, and that is an important part. So I think if that is something which is a much higher threshold, everybody is affected, but this is a much higher. Once you understand, even in Prashant Bhushan case, the Supreme Court said truth is not good enough. Even if you are saying what is truthful, but if you are bringing the dignity of the court down or the chief justice down, that's not good defense. You are still in contempt, criminal contempt. That was hell, and he was fined 1 rupees as a fine, and that is the important thing. So basically, what we have to think about is these views on social media, anonymous. This is going to stay. What we need to think about it, and we need to bring intermediaries, and intermediaries can correct it. Like in the UK, there are one or two IT acts which looks at this. So therefore, when there is a mass campaign, like you're saying, thousands of mails going out, thousands of view going out, which is derogatory to the institution, if that is the case, or whether it's a chief justice, whether it's a high court judge or a supreme court, if it is a derogatory, if that is what it is, and it is not related to the judgment, it is not related to what he has done, that is a contempt. And if because it's a contempt, you need to bring laws to protect that level of information. Whether there is a truth or not truth is not relevant. What is important is that a mass media type of a campaign against an individual which holds office of judicial office, and therefore the integrity of judiciary is involved, which is one of the basic structure, the independence and integrity of judiciary. Therefore, in that situation, there need to be a strong, I would say, defense mechanism of making sure, to the extent we can say that this they have verified the fact it is incorrect. But on the other hand, to make sure the intermediaries, there should be a law where intermediary understand that if the subject matter is a sitting high court judge or a supreme court judge, and there is a campaign, then they are liable, and therefore they need to be actively working to bring those things down. And there should be a rule book to that extent, because a lot of time we all work for intermediaries. They say, oh, we can't do anything, somebody's posting it. But you need to understand at certain points cannot do that, and that is what it is important. And maybe whether you have a law to that effect, or you have a judgment to that effect, and make sure that you don't need to give notice, they need to be vigilant whenever, like it's a very easy thing when you put a post on a sitting high court and supreme court judge. You have, in a way, you get alerts, and you are able to look at it, and you are able to see that if it is it is being, somebody is being attacked personally, not the judgment, then they need to bring it down. As long as they keep bringing it down, I think we probably have to live with it. And there should be some sort of a mechanism by which the one designated officer of a high court or a supreme court should come and say that this is incorrect, they have looked at it. That all will happen, because this is I'm telling you, Tarun, my office is young people. They enjoy gossip all the time. There's a young people, they love gossip, and social media is a great place to gossip. They can spend hours and hours doing that, and we probably have to live with that, and we have to regulate it only in cases where it gets to integrity of judiciary, not in all cases. Otherwise, we'll have a police raj again.
Very well put, Mr. Saraf. You're saying that in case the allegations cross a certain level of frivolousness, the law can take its course. You can lift the veil and find out who it is, but otherwise, till it is harmless and not troubling anybody, it doesn't bother. Point well made. I'll go to Amit Nayak, managing partner of Nayak and Nayak, for his comment.
So look, I agree with Mohit what he said, that there has to be a threshold. I also recognize that there is freedom of speech, but I must say this, keeping the topic that you have sort of articulated, that look, I think in the case of judges, it's a mere smear attack, and it's always the timing. And I am very clear that the Information Technology Act needs serious amendments. Also, you must know, Tarun, that today the cyber cells in India are extremely competent and well equipped. I have done many matters where we've been able to go out and find out the offenders. I think the time has come that cyber cells act suo motu. You see, you don't need a complaint for the purposes of a cognizance even under this act. And I think that's why we need to change things. Because I think vigilance is very important even from a cyber perspective. And unless and until, like Justice Roy said, you hold the intermediaries accountable, there is no responsibility. And unless you have somebody accountable, you're not going to do it. I also feel this, Tarun, that as far as judges are concerned, I think a time has come, because today everything is in the public domain. I think judges must speak up. There is no harm, because you see, where it's not related to a matter before you, it is a matter which is a personal attack. I don't see why a judge should be restricted from speaking, but I don't think that's a breach of any constitutional function that a judge does. Because the judge's function as a constitutional functionary is to deliver his judgment, which he's doing. But today, if his family is attacked, today, if he's attacked, today, anything is done, there must be a defense. And I don't know why judges cannot speak up. I don't think why they should be treated differently from any other individual outside their judgments. And therefore, a time has come where judges must speak, and I don't think there could be a better time. You're on mute.
Thank you for articulating this. Some of the judges in the Supreme Court have also said on the same lines that a judge should also go out and speak and articulate, but they themselves do it less. Maybe there are reasons for it, but they say that as an exception, of course, they can sometimes speak. I'll go to Justice Rishikesh Roy for his rounding up comments for today's discussion.
Okay, couple of takeaways from what Mohit has said and what Amit has said. And let me take the last one that was said by Amit, that the judges must speak up. Now, the judges are capable and are able to speak well through their judgment, but each judge may not be equally capable of, answering things in a press perspective or a social media perspective. So actually, you are then leaving the defense of the judge to the individual capability of a judge to rise to the occasion. Occasionally, a judge you might find, I mean, we don't have to name any particular judge, they are very media savvy and they can speak and they can clarify. But you can't expect all the judges of the high courts and the Supreme Court to be equally media savvy. So that is my thing. So, but one more thing which is also troubling, because when you have a right to criticize the judgment, fine. But when you criticize a judge or run a campaign against not the judgment, but against family, against property. Now, all of us as judges, we know that we have to declare our assets. So, obviously, somebody is running a false campaign. In that case, there has to be a cyber vigilance. The as we have discussed already, there could be an authority which might verify and say that, oh, this is a false campaign that is being run, and then there might be self measures or even rules and regulation for the intermediaries to sort of stop if they see a trend, because now immediately things should come to light that hundreds and thousands of messages are going. Now, is it truth or is it just a campaign, a mischievous campaign that's been going on? So then they should step in suo moto. So these two are things which I feel need to be said. And particularly when anonymous complained, and on that Mohit made a very interesting comment about his office having many young people and they enjoy the gossip. Let me tell Mohit, Amit, and Tarun that even not so young people also enjoy their time of gossip.
That is very well summed up. We'll quickly go to Mohit and Umit for their summing up comments. Mohit Saraf, over to you for your summing up.
I would say that we need to think a lot before judges come and respond to such allegation, because nothing will get settled. You go and say yes and say no, and that will say no, this is the case, and we see that regularly on TV. So I would say maybe a judge clarifying, because you cannot really, and most of these allegations are based on certain facts or certain things somebody has done in 20 years back. How can you clarify? So I would say probably it will be good not for judges not to get into this public discussion, because that will not end into a good position. That's number one. Number two, there should be an officer of the court to some extent if there are issues which he can quickly verify, because a lot of things you cannot quickly verify. Then it will be the worst case is that you have an opportunity to speak but nobody could verify. That means it must be truth, because it takes time to verify if something has happened 20 years back, 10 years back. So I would say really at the end of the day, I think also, Tarun, we missing out something that the bar lawyers of India, Bar Association, Bar Council, they should have a role to play in this. In my view, that's a very important way to negate this because really they represent judiciary. If they also respect, they also they have a stakeholder. If there is independence and integrity of judiciary is maintained, and they should take active role in that because whenever some criticism crosses the limit, when it becomes personal, and when you're defaming a judge because he's done something or something else 20 years back and you've not raised that issue 20 years and now you're raising it because that person is about to be elevated, I think the bar should take a very strong view. And I think what Amit said, that even there are certain organizations in India, they can easily find out who are doing it, and you should bring them to contempt, bring them publicly to contempt, and you can do all those things because I think important thing is we have to allow transparency, we have to allow freedom for people to express even in anonymous way. But if there is a campaign, orchestrated campaign against an individual to defame at an important occasion, and particularly if he belongs to judiciary, I think there should be a very strong action against the intermediary and uh, against such individual, and whatever it needs to do, or whether there's a new IT or act or whatever it needs to be done, it should be done. Because in my view, if these type of things continue, a lot of people will lose faith because there a lot of people have just heard it and they believe it. They don't even know, and that we should not allow. As we are all stakeholders in independence of judiciary, and that should not be allowed at any cost.
Point very well taken. I'll go to Meet Naik, managing partner of Nayak and Nayak, for his summing up comments.
First of all, I must thank you, and each of us must thank you, because I think the role that the legal media is playing today is very important. Because please understand, the legal media is not confined, like I alluded to earlier, today to only the legal profession. Everybody watches YouTube. Everybody watches most of the legal news that goes up. So I think it's a responsible legal media that is very important to deprecate any such criticism. And I think that's the very important role. And I thank you for doing this show. Point number one. Point number two, as I said, if the wings of the executive and the legislature have a spokesperson, I think the time has come for the judiciary to have an institutional spokesperson. And I don't see why in today's age and day that cannot happen. Because what the judge, like Justice Roy said, can't say in his defense, I'm sure a spokesperson can say. Second, and the third most important thing is that I feel that the time now has come where the timing, say any criticism in the last couple of weeks, in the last couple of months, to a particular judge, strict action must be sent out by the judiciary, and suo motu action must be taken. And I think it could be by brother judges. I think here's where judges need to stand for judges. I think this is where the time has come where the judges must issue suo motu action. And if they don't do it, I'm sure, I mean, they should do it. If they don't do it, that would be unfair to the brother judge. This is where I would end my comment. Thank you.
Thank you. Thank you. It was a good discussion today, and I'm thankful because these are not your matters. This is not case that you argued for, but all of you came for the institution. So I would like to thank Justice Rishikesh Roy, Senior Mohit Saraf, Managing Partner, Saraf and Partners. Amit Nayak joins us from Mumbai, Managing Partner, Nayak and Nayak. You came, you lent your voice to this because I think this is one issue where the bar and the bench must come together. Can't be just a bench issue because justice involves us all. And this is a time where the institution should stand up when anonymous accounts end up attacking judges and making some very, very unfounded allegations. Appreciate your joining us and really appreciate the time that all of you have given us today. Thank you so very much. Thank you.
Thank you.
Thank you, Tarun.
Thank you.
Thank you, Tarun. Thank you.
Thank you.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.